Most people think a head-on collision is a simple liability claim, but this case ended with serious injuries in a fight with an insurance company. Hi everyone, I'm Ryan Wynn with Wind Injury Law. I want to talk about a recent case involving car accidents and explain what happened and what people should understand if they ever find themselves in a similar situation. This case involved a head-on collision in New Kent County. Our client was a passenger in a car driving on a two-lane road when a car coming from the opposite direction crossed the center line and hit her head-on. It was a massive impact that caused our client to be in immediate and extreme pain. Her injuries were mainly to her feet and toes. The impact was so severe it crushed her feet, resulting in over a dozen broken bones. At first you would think this is a straightforward case. We had an extremely nice client who was hit head-on that resulted in major injuries. Not even the insurance company could argue the accident was at all my client's fault, nor could they make an argument that the over 12 broken bones in her feet and toes were a pre-existing condition. What happened was the defendant was following a car that stopped on the two-lane road, and the defendant claimed that she was not able to stop because her brakes failed, causing her to make the decision to jerk the wheel and go into oncoming traffic. In Virginia, if the defendant can prove they actually experienced a sudden mechanical emergency, like their brakes failing or tire blowing out, then they are not liable. So we had a client that was badly injured, did nothing wrong, but was faced with the possibility of not being able to recover if this defense was successful. The insurance company initially denied the claim, arguing that the defendant was not legally responsible because her brakes failed. We had no choice but to file suit and issue discovery. We'd already obtained the police report, as well as interviews of the investigating officer and witnesses. In discovery, we requested maintenance and repair records. We were able to obtain some evidence to help us, but the brake failure defense was still very valuable until we took the deposition of the defendant. After that, everything changed. During the defendant's deposition, I was able to ask questions about her specific knowledge of the car, and it came out that she was aware that her brakes were not working properly, and in fact had purchased new brakes a few days before the collision but had not had them installed yet. After this was revealed, their defense of brake failure was gone with the wind. This revelation totally changed the course of the case and the defense's position. The defense offer went from zero to over $500,000. We were able to get an outstanding result for a very deserving and nice client. If you take anything away from this case, take this. Having an attorney involved, especially early, can make all the difference. As I tell people often, you will never regret consulting an attorney early on, but you likely will regret it if you do not. If you found this helpful, make sure to like and follow for more real case breakdowns and legal tips. If you or someone you know has been injured, call Wind Injury Law for a free consultation. The call costs nothing and you don't pay anything unless we're able to be successful on your behalf. And always remember, Wind Injury Law is here for you, Virginia.